everyone. Today, myself, CA Manmeet Kaur Khanuja, being the moderator of this webinar, welcome you all on behalf of our Committee on Commercial Laws, Economic Advisory and NPO of ICAI. Today, we take proud in welcoming our eminent speaker, Dr. Puneet Gupta. So, welcome. It is my pleasure to be a moderator in this webinar organized on contract labor, rights, risk and responsibilities of principal employers and contractors. In a short while, we'll start this webinar. I would like to apprise you all on the committee working of our ICI. This committee is basically focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social values while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation to develop and publish technical guidance, background materials, etc., and to create awareness of professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO. Our eminent speaker will talk on contract labor, rights, risk and responsibilities of principal employers and contractors in this webinar, and we hope that the same shall be useful to all the members. Welcoming our eminent speaker, Dr. Puneet is a partner at EY India. He has been with EY India for 16 plus years and is the solution lead for people and regulations related service offering for EY India. He has an extensive experience in working with multiple organizations on various aspects of employees related regulations such as Provident Fund and other central and state regulations. He is a Bachelor in Commerce from Delhi University and an associate member of the ICI holding AIR 16. He regularly contributes articles on labor codes and social security issues for major businesses and finance portals. Over to you, sir.
Thank you, everyone. Thank you for the ICI team, for the committee team to give me this opportunity, and thank you so much, CM Manmeet Kaur, for that elaborate and detailed description of my credentials. Thank you so much. I'm CA Puneet Gupta, not Doctor. CA Puneet Gupta. I am a partner with EY, and I specialize on all aspects of labor and employment law. And it can be quite funny for a chartered accountant to be a subject matter experts on labor laws, but here I am before you, a partner at EY, and focused on all aspects of labor and employment law. Today, I'm going to focus on this whole piece around contract labor. So whether you take up service company or you see manufacturing sector, a large part of employment that are done in today's organization is done as contingent workforce. And when we talk about contingent workforce, one of the main options for companies to hire employees is through contractors and third parties. When an organization hires employees through contractors and third parties, there are a lot of these rights that the contract labor enjoy. There are a lot of risks and responsibilities that principal employers and contractors take on, and we're going to decipher all of this and discuss all of this over next 1.5 to 2 hours. With that, Sneha, if you can move to content slide page. Yeah, the way we plan this session, we'll start to talk about the applicability of the CLRA Act, what it's covered under the Contract Labor Regulation Act, what are the various dimensions of it. We'll talk about various possible scenarios that could apply when an organization hires employees through third parties, and when would CLRA be applicable or not applicable. What are those obligations of contractors or agencies that are supplying manpower to an organization? What are obligations of principal employer when taking on resources or employees from a third party? And I go into these terms, contractors, principal employers, in great detail and explain through practical examples. Then we'll discuss whether or not there are any restrictions on engaging contract labor to third parties. Uh, we also will spend a little bit time on what are those additional obligations under the new labor codes that are still under discussion have not been finally implemented, some case studies on possible risk, and will leave you with a suggested approach from my side on what is it that we as chartered accountants can take to clients, or if we are chartered accountants working in a client organization in an organization, then what is the approach that we can follow for our respective organizations. So that's the flow of the session. Before I get into technicals, just to explain you how important this landscape is, if you see, the government of India has done this annual survey of industries specifically for manufacturing sector for FY23. This survey was actually released in September 2024, where the government reviewed some 2.5 lakh factories, compliance status in these 2.5 lakh factories. And they said, or they came up with a number that in those 2.5 lakh factories, almost 40%, 41% of employees are engaged as contract workers. And contract workers means any individual that is hired through a third party. And I would probably say that this is still a very conservative number. The actual number, to my mind, probably will be much more. Um, and also the fact that it has been on an increasing trend. So if you look at the same percentage in FY20, it was about 38%. It's increased to 41% in FY23 and is further increasing as time passes. So increasing trend of organizations hiring employees as contract workers or as third parties. And then there are these quarterly employment surveys, which also show different numbers. But like I said, these are, to my mind, very, very conservative numbers. If you talk to any large manufacturing organization, a large part of employees that are hired on shop floor today are all employees that are hired through contractors and third parties. And there's a lot of compliance, there's a lot of issues that crop in or are applicable to those third party arrangements, and that is what we'll talk about over the session today. If I were to also give you some dimensions across the India, so as part of this annual survey only, they've said that there are states like Bihar, Telangana, Uttarakhand, Odisha, Maharashtra that do large scale. The trend of third party hiring is much more in these states. But there are states like Kerala, Tamil Nadu, Punjab, Himachal Pradesh, Karnataka, Delhi, where there is slightly lower trend of employees being hired through third parties. So that also is different across different states. Now, when I talk about contract labor, Sneha, we can move the slide. When I talk about contract labor, while the focus is CLRA, which is Contract Labor Regulation and Abolition Act 1970, but there are multiple other regulations or labor laws that come into play. So we'll touch upon a little bit of Provident Fund Act, ESI Act, gratuity, maternity benefit, minimum wages, payment of wages act, and of course the Industrial Disputes Act. So there are a number of labor laws that are applicable when we talk about contract labor piece. Why is this topic important? This topic is important because when organizations engage through third parties or hire employees through contractors, there are a lot of risk, a lot of compliances that are applicable for both the contractor and the principal employer. And that is the opportunity for us as chartered accountants to help our clients with. Now let's look at some definitions. When we talk about contract labor, there are basically three players or three different individuals or three stakeholders that come to play. One is the contractor. A contractor is an agent or a agency or a vendor that is supplying manpower to the principal employer. So contractor basically is the entity that is legally employing individuals and then transferring those individuals or allowing a third party, allowing a principal employer to use those individuals. So that's the first player. The second is the principal employer, which is basically the user entity. So a principal employer takes employees for its business from contractor for day-to-day work. So principal employer is the second player, which is the user entity. And third is the contract labor, which is basically the individual that is being sent by contractor to principal employer for work. So we'll have to look at all of these three aspects: the contractor, the supplier of manpower, principal employer, the user of the manpower, and the manpower itself, himself, herself, which is the contract labor. Now, if you look at the definition of stay there, now, if you look at the definition of contractor under the CLRA, contractor in relation to establishment means a person who undertakes to produce a given result for the establishment other than mere supplier of goods through contract labor or supplies contract labor for any work of the establishment. So, very simply put, anyone that is using any agency that is using contract labor to either deliver results for an establishment or supplies that contract labor to a user entity is the contractor. It also includes a subcontractor. So if entity A has given work to entity B and entity B has subcontracted that to entity C will also be contractor under the CLRA Act. So subcontractors or sub vendors are also covered as contractors under the CLRA Act. The second player is the principal employer, which is, like I said, is only the user entity. And if you see who's responsible as principal employer in relation to factory means the owner, occupier, manager of the factory. For a mine, again, owner, agent, manager of the mine. But in relation to other establishment, person responsible for supervision and control of the establishment. So for all compliances that we're going to talk about, it's for a factory, it's the owner, the occupier of that factory. And for other companies, service companies, it's basically the managing director, the person who has overall control and supervision of the establishment. That person is considered as principal employer for this law purposes. And establishment can be any entity where any kind of trade, business, manufacturing, or occupation is being carried on. So whether it is a service company, whether it is a financial services company, whether it is a manufacturing entity, wherever you have a user entity who's taken resources from a third party, that entity could be principal employer from a CLRA perspective. So these are two players. If you now move on, the third player, which is the contract labor. If you look at the definition of contract labor, there are two parts to it. It says a contract labor means a workman who shall be deemed to be employed as contract labor when the workman is hired in or in connection with work of establishment by or through a contractor with or without knowledge of the principal employer. Basically, it says that for an individual to be contract labor, the person first has to be a workman, and there is a full-fledged definition of workman under the law. I'll come to that. But person has to be first a workman, and second, he or she should be hired by contractor in or in connection with the work of an establishment. And establishment means the principal employer establishment. So when you have an individual who is a workman as defined under the law, and that person is hired specifically for a contract for a principal employer, that person qualifies as contract labor under the CLRA Act. If I now talk about, so therefore, the first important element for someone to be contract labor is that the person should be a workman. Now, if you look at the definition of workman under the CLRA Act, workman means any person employed in an establishment to do any skilled, semi skilled, manual, clerical, supervisory work, but does not include a person who's either in a managerial or administrative role or in a supervisory role drawing wages exceeding certain limit, or is an outworker. Outworker means people who just take goods and work from home. But basically, contract labor definition does not cover individual in a managerial or administrative or a supervisory role. Now, if you apply this in reality, it basically means that an individual who has some level of managerial role or is a supervisor, is a people manager, then that person is excluded from the definition of workmen. And therefore, you will apply the two definitions together. First, a person has to be a workman. So if the person is a manager or in managerial role or in a supervisory role, then that person is not a workman. If that person is not a workman, then that person will also not be a contract labor. But if that person is a workman, therefore he or she is not in a managerial role and is hired specifically in or in connection with work of a principal employer, then that individual qualifies as contract labor, and the um, entity that is supplying that contract labor, or entity that has legally engaged or employed that contract labor, qualifies as the contractor, and the entity to which this contract labor is supplied qualifies as the principal employer. So these are the three players: contractor, principal employer, and contract labor under the CLRA Act. I'll give you an example, very simple. Let's say you have a security, you are an organization, say an organization manufacturing electronic parts. That factory has hired security guards through a security service agency, where the security service agency will hire individuals as security guards on their payroll and supply those security guards to the factory. In this scenario, the security guards will qualify as contract labor. The security service agency that has employed those security guards will qualify as the contractor, and the factory where these security guards are working on a day-to-day basis qualify as the principal employer. That's how practically this scenario works. Now, for the law to be applicable, for contract labor regulation to be applicable, there are limits. So just because a principal employer has engaged 5 employees through contractor does not mean that CLRA Act is applicable. For CLRA Act to be applicable, the principal employer or the establishment should have employed at least 20 or more contract labor, and then CLRA will be applicable. For example, a principal employer organization has hired um, uh, only 10 contract labor through security service company, housekeeping service company, manpower supply companies, etc., then CLRA will not be applicable. But if a principal employer through one or more contractors have engaged 20 or more contract labor, then CLRA Act is applicable for the principal employer. And in future slides, we'll discuss why this is important. Second, for contractor, CLRA Act is applicable if the contractor has engaged 20 or more workmen. So if you have, say, a security service company or any housekeeping company or a manpower supply company that has engaged 20 or more workmen on its payroll, then CLRA Act is applicable as per the CLRA Act law. However, certain states in India have either increased this threshold of 20 or reduced this threshold of 20. So, for example, states like Haryana, Maharashtra, Tamil Nadu, Gujarat have increased the ceiling limit from 20 to 50. So, in these states, CLRA Act is only applicable if the principal employer has engaged 50 or more contractors. Like state like Karnataka has kept the limit as 20, so no change there. And there are states like Telangana, for example, that have reduced the limit from 20 to 5. So in Telangana, if you have a principal employer entity that has engaged 5 or more contract labor through one or more contractors, then CLRA Act is still applicable. So therefore, when you're advising a particular client, you will have to look at the threshold applicability for that respective states. All states have different limits for applicability of CLRA in India. There's also one exception in the law. The exception in the law is that CLRA Act does not apply to establishments in which work of any intermittent or casual nature is performed. So simply put, if and this has also been defined in the law to say that if someone is working for less than 120 days, then that will qualify as intermittent or casual nature. If an organization needs that work to be done for more than 120 days, that will not be intermittent or casual nature. Again, I'll explain through an example. Let's say you have a factory and the factory needs security guards. The security guards, of course, will be needed right through the year, every day in the year. So, therefore, security services will not be considered as intermittent or casual nature. But let's say that factory needs certain uh, certain repairs for which they've called contract labor to do work for, say, 1 month, because that is not the main activity and is only carried out for less than 120 days. It can qualify as intermittent or casual in nature and can be outside CLRA applicability. So, when again advising clients or looking at compliance for a specific organization, there are two or three things to be seen. One, the relationship between contractor, principal employer, and contract labor. Second, whether or not these thresholds are met, because the law is only applicable if the threshold is met. And third, whether or not the activity can be covered as intermittent or casual in nature. If the contract labor relationship is established, you have more contract labor than the specified threshold, and the contract labor works for more than 120 days in that organization, then CLRA Act is applicable. So, therefore, we have to look at these three aspects. Now, this defines how and when CLRA Act is applicable. That's the first part of the discussion. The second part of the discussion are different hiring options or different models of hiring and when CLRA Act is applicable or not applicable. So we look at first scenario, scenario one. Now, these are the features of the first scenario where a contract is a principal to principal contract for services. I'm sure as chartered accountants, we all know the difference between contract for services and contract of services. Contract for services means a contract where two parties agree that one party will provide services to the other party. If that is the arrangement, then it is a contract for services, not a contract for manpower supply. So, if it's a pure service contract that does not involve supply of manpower, we can adopt a position that CLRA Act is not applicable for such contracts, and therefore the company that is using those services of contractor does not qualify as principal employer and does not have any obligations under CLRA Act. I'll again explain through an example. Let's say as CAs, you have a CA firm and you're providing some, say, consulting services to your client. That arrangement between a CA firm and the client is a contract for services, do not involve manpower supply, the CA firm will not constitute or will not qualify as contractor, and the client that is using the services of the CA firm will not qualify as principal employer under the CLRA. So and this obviously this cannot be just a reading of the contract. This is a very fact based a determination on whether it is contract for services or contract for manpower supply. But that is first scenario. Now, how do you determine? The million-dollar question is, how do you determine whether it is a contract of for services or contract for manpower supply? Over past many years, multiple courts have laid down various judicial precedents to determine what constitutes service contract versus a manpower supply contract. And these are some indicative factors or parameters. So, for example, if the control and supervision lies with the contractor and not with the user entity, where the work carried out by the individual is integral to the business of the contractor and not the user entity, the risk and responsibility of the work is of the contractor and not the user entity, and all of these other factors are established. The contractor, the agency, has the right to select and terminate services, has right to initiate disciplinary action, is using the premises of the contractor, the agency who is engaged that individual. The tools, the equipment is all provided by the contractor. um, the amenities are provided by the contractor. there is no exclusivity that contractor can work for multiple clients. If all of these conditions are satisfied, then we can take a position that it is a service contract between the contractor or the agency and the user entity, and not a manpower supply contract. Again, if you apply this, all of these parameters in the example that I gave for a CA firm providing consulting services to its client, all of these risks and all of these parameters are established between the CA firm and the individual, not between the client and the individual. And therefore, it can be considered as a service contract and not a manpower supply, and therefore CLRA may not be applicable. That's a simple scenario one. Scenario two, yeah, is a arrangement where there is manpower supply, but that manpower supply is not covered under CLRA. Now, the facts of the case or the scenario will be that there is a contract for supply of manpower, but either the manpower is not engaged specifically in or in connection with work of the principal employer. If you see the definition of contract labor, and Sneha, if you can just go to that slide for a minute, the definition of contract labor. If you look at the definition of contract labor, for someone to be contract labor, he or she should be hired in or in connection with the work of establishment. Establishment means principal employer establishment. So when the contractor is engaging an individual specifically for the work of principal employer, that's when contract labor relationship is established. um, so if in that scenario, we take a view that the person is not hired by the contractor specifically for the establishment, or the person is not a workman. Remember, I said that the starting point for someone to be contract labor is that the person should be a workman. So if the person is either not engaged specifically in or in connection with work of establishment, or is not a workman, then that individual will not qualify as contract labor. Even if, and if that individual does not qualify as contract labor, the entity that is supplying that individual will not qualify as contractor, and the entity that is using that individual will not qualify as principal employer, and SALR is not applicable. And therefore, not every manpower supply contract will be covered under SALRA. If the individuals are not hired specifically for contractors or do not qualify as workmen, CLRA Act will still not apply. So that's scenario two. Then there is a scenario three, where there is a supply of manpower which is covered under CLRA Act. Now, the facts of this scenario are that there is a contract that involves supply of manpower by one agency to a user entity. The individual that is supplied, the manpower, is engaged specifically in or in connection with work of the establishment, which means engaged specifically in or in connection with work of the principal employer, and the individual qualifies as a workman. Uh, if these conditions are satisfied, then the individual will qualify as contract labor. The entity that is supplying this manpower will qualify as contractor, and the entity that is using these services of contract labor will qualify as principal employer under the SALRA Act, and all obligations under the SALRA Act will have to be complied with. So therefore, when determining whether or not SALRA Act is applicable, the determination of whether or not that individual is a contract labor becomes really the starting point, the one of the most important point for us to consider. Let me explain this through an example, through a case study or through a judicial precedent. This I would call is a landmark judicial precedent by Odisha High Court. This is in the case of Basanta Kumar Mohanty versus the state of Odisha. This ruling came in 1991. The issue before this ruling was that security guards engaged through a third party in the establishment of principal employer, whether or not they qualify as contract labor. So one entity has supplied security guard to another entity. The question was whether the security guards could qualify as contract labor. And this is important because if the security guards qualify as contract labor, then the agency, the security service company, will qualify as contractor, and the user entity will qualify as principal employer under CLRA. Now, see what the Odisha High Court had said. Odisha High Court said that if a permanent employee who, during his employment, can be placed at different establishments at the choice of contractor, then that permanent employee of the contractor is not a contract labor because he or she is not hired in or in connection with work of any particular establishment. That's a very, very important line. The Odisha High Court held that given security guards can move from organization to organization, they are engaged with a security service company, but that security service company can place them at different clients of the security service company. They're not hired by the security service company for a specific uh, client. The security guards will not qualify as contract labor, and CLRA Act is not applicable. This is one of the landmark rulings of the Odisha High Court. Now, this same principle, if you stay down, the same principle which is laid down by Odisha High Court in Pasanta Kumar Mohanty versus State of Odisha, this same principle has been incorporated by the central government in the new labor codes. So when they have provided the definition of contract labor under the new labor codes, under new occupational safety, health, and working conditions code 2020, which is one of the four labor codes that the government is trying to bring in, they have specifically used the same rationale and said that if a worker is regularly employed by contractor for any activity of his establishment, which is the establishment of the contractor here, and the employment is governed by mutually accepted standards of conditions of employment, which means that there is an active employment between the contractor and that individual. In that case, the individual will not qualify as contract labor. So the same principles that were laid down by Odisha High Court in 1991 have been incorporated by the central government in the new labor codes. This is in the new law, not in the new current law. And because that principle does not exist clearly under the current law, it is always a matter of debate, always a matter of litigation on whether or not an individual will qualify as contract labor. So, a lot of times we see labor codes, etc., giving rulings that individuals qualify as contract labor because that's how they want to protect the rights of individuals. But if we look at the law technically, there are options where we can take a view that individual who's a permanent employee of contractor and keeps moving between clients, that individual uh, is not a contract labor, and CLRA Act is not applicable. Let's move on. So what we've done up until now, we've looked at two things. A, we've looked at when would a contractor, principal employer, and contract labor relationship establish. So we went through the details of these three definitions: contractor, contract labor, and principal employer. Second, we've looked at three different scenarios on how that definition is to be applied and when would the individual engaged through third party qualify as contract labor. Now we move to the third part, which is obligations of contractor. Now, assuming the third party agency qualifies as contractor under CLRA Act, what are the applicable compliances that are applicable for contractors under the CLRA law is what we will spend time on. Now, if you see on the slide, there are 9 different compliances or obligations that are applicable for contractors. We'll talk about each one of them. The first, under CLRA Act, a contractor is required to obtain a license. In fact, the law very clearly lays down that if a contractor is supplying any contract labor to a third party, that cannot be done till the time contractor has obtained a license under the CLRA Act. So this license have to be obtained from labor authorities before contractor um, deploys contract labor to any client. Now, when we obtain this license, practically, I want to share that there are a lot of conditions that are laid down in that license for contractor to comply with. So, if you are helping clients with obtaining licenses under CLRA Act, or if in your organization you supply manpower to third parties and obtain license, then it's very important for the contractor to look at that license and ensure that various conditions that are put on that license are complied with. So there are conditions like the fact that contractor should not pay less than minimum wages to its employees, should pay wages by a certain timeline, should not pay wages lower than the wages paid by principal employer to its permanent employees, so on and so forth. So therefore important that contractors look at these licenses and ensure that they comply with various conditions that are laid down in those licenses. So that's the first compliance that the contractor has to comply with. The second is to obtain amendments and renewals of license. So these licenses that are granted to contractors are for a defined period, subject to defined conditions. There could be situations where contractor license has either expired or will need to be amended, and therefore contractor should take that amendment or renewal within the defined timeline. In fact, I can share that different states again have different timeline for obtaining amendments or renewals. States like Karnataka, Haryana, Telangana, Gujarat requires renewal to be done 30 days before expiry, while states like Maharashtra, Tamil Nadu requires renewal of license to be done 60 days before expiry. So continuous monitoring of these licenses are important to identify when they would expire and for contractor to obtain renewals within or before this required timeline. Now, when would a contractor license be amended? May need to be amended. There could be various situations. For example, initially a contractor has engaged to or agreed to provide 50 contract labor, but the principal employer wants more employees and now supplying 75 contract labor. Before supplying any additional employee, an amendment is required. So if there is a change in headcount or change in the nature of work or change in work location or change in duration of contract or any other change, then an amendment to license is required in advance. So that's compliance number two. Compliance number three, ensure payment of wages to contract labor before the expiry of a period specified. So under the law, they say that if you have more than 1,000 workers, then salary should be paid before 10th of the next month. So contractor needs to ensure that they pay contract labor, they pay to the individuals before the required time period. Then comply with all the statutory provisions under the contract labor. Now, understand this, the contractor is the legal employer of these individuals. So, all the statutory provisions under PF, ESI, maternity benefit, employees' compensation, all the labor laws that are applicable, it is the contractor's ultimate obligation to ensure compliance with all statutory provisions. Then, under the CLRA Act, there are various registers and returns to be filed. Um, so, the contractor should ensure that all of those registers are prepared and returns are filed on time. In fact, I can also share that generally most states require a half yearly return to be filed by 30 or 31st July every year. So contractors should ensure that A, they maintain the required registers, and second, they file their half-yearly returns on time wherever they are qualifying as contractor under the CLRA Act. So that's condition number 5. Condition number 6, there is a legal requirement, though this is outdated now and may not be relevant, but there is a legal requirement that the contractor should disburse wages in the presence of authorized representative of the principal employer. Now, of course, all salary payouts generally are done online through bank transfer, so this is not applicable. But what principal employers generally do, they take a proof of disbursement of wages by contractor to contract labor and keep that on records to ensure that they're compliant with this condition. Then point number 7, um, under the CLRA Act, there are various benefits that are required to be provided by contractor to individual employees. So, for example, if you have more than 100 contract labor engaged in any entity, then the contractor has to supply or give canteen facility to the contract labor. If you have more than a certain number of individuals working on night shift, or and especially if they're working for more than 3 months, then there is a requirement to provide restrooms. In certain cases, if you have more than 150 contract labor, you need to provide first aid facilities. So all of these facilities that are required to be provided by contractor to contract labor, all of these will need to be complied with. That's condition number 7. Condition number 8 is about crash or restroom. So if you have contractors that are that having contract labor that have children under 6 years of age, then there is a requirement to provide certain rooms for them, so that they can look after their children. And the last condition, again, very important, that the contractor needs to ensure that the contractor pays same wage rate, holidays, hours of work, and conditions of service as principal employer gives to their permanent employees doing the same or similar kind of work. Now, this is a very important condition where the law says that if a contractor is providing contract labor to a principal employer, and principal employer also has their own permanent employees doing the same or similar kind of work. Let's say, for example, a contractor has given a technician to the principal employer, and principal employer also have hired technician on their own payroll, and both individuals, the contract labor and the permanent employee, is doing the same or similar kind of work, then the law puts an onus on the contractor to ensure that the wage rates, holidays, hours of work, and other conditions of service that the contractor provides to the contract labor is similar to the conditions that are applicable to those permanent employees. Now, this is again one very litigative matter under the CLRA Act, which the contractors need to comply with. So, these are really 9 key obligations of contractors under the CLRA Act, which the contractors need to comply with. Let me take an example on this, or a case study on this. This is a Supreme Court of India ruling in the case of Hindustan Steel Works Construction Limited versus the Commissioner of Labor. This is a 1996 ruling where the matter before the Supreme Court was whether it is principal employer's responsibility or liability to pay differential wages to contract labor for doing similar work as regular employees. Now, Sneha, if you go to the previous slide for just a second, if you see that last condition, condition number 9, this is an obligation on the contractor, not on the principal employer. So, therefore, it is contractor's responsibility to ensure that the wage rate, holidays, hours of work, and conditions of service for contract labor is similar to that of regular employees of the principal employer. In that case, before the Supreme Court, it was debated whether principal employer is liable to pay the differential wages, where the Supreme Court ruled in favor of the principal employer and held that this responsibility is on the contractor and not on the principal employer. So, if the contractor has committed a breach of conditions of license, then he alone will be responsible. That obligation to match wage rate to regular employees of principal employer is not an obligation of principal employer but on the contractor. So, especially for organizations that supply manpower to clients, they need to ensure that the wage rate, holidays, conditions of service that are applicable in their organization is similar to that of uh, regular workers of that principal employer, if the regular workers and the contract labor are doing same and similar kind of work. And generally you determine same or similar kind of work basis the skill set, experience, effort. If the two individuals, say hired as technician, are doing different work, have different level of experience, have different level of role, then they cannot be equated and this obligation will not arise. But if the two technicians have similar role, similar profile, similar experience, then this condition will be applicable. So this is important because this is one of the most litigative issue under SAIL-RA Act. So those are the obligations of the contractor. Now let's look at the obligations of the principal employer. There are six key obligations on principal employer under the SAIL-RA Act. One is to obtain registration for the establishment as principal employer. So while if you understand the SAIL-RA Act, the contractor obtains contractor license, the principal employer obtains principal employer registration certificate. This allows the principal employer to engage contract labor in their organization. Remember, principal employer is the user entity that is taking contract labor from multiple contractors. Principal employer has to obtain contract labor registration certificate to ensure that it can engage contract labor through multiple vendors. That's the first compliance. The second compliance is to obtain amendment for the principal employer registration. Now, similar to a contractor license, there could be situations where principal employer need to obtain amendment to their principal employer registration certificate. And again, different states have different timeline uh, uh, when this amendment is required. Like most states, like Haryana, Karnataka, Telangana, Tamil Nadu, require amendments within 30 days of change. And I'll explain situations where amendment is required, but it is after 30 days of change. There are states like Maharashtra and Gujarat where such amendment is required within 50 days of change. So, what are these changes or what are these amendments that may be needed to principal employer registration certificate? In the principal employer registration certificate, two key things that come in are number of contractors and number of contract labor. So if there is any change in contractor, any change in the number of contract labor, then the registration certificate needs to be amended. Or if there is any change in the nature of work, there is any change in the name of the employer, then principal employer needs to amend the principal employer registration certificate. So those are first and second obligation. The third obligation is to pay wages to contract labor in the event of default by the contractor. Now, the requirement is that obviously as legal employer, it is the contractor, the legal employer who will pay wages to the contract labor. But in case contractor defaults in payment of wages, the owner shift from contractor to the principal employer. So therefore, if you hired in any organization hired contract labor through contractors and contractor defaults, then it becomes responsibility of the principal employer. Now the law also states that in case where the principal employer is paying salary to contract labor on behalf of contractor because the contractor has defaulted, while it becomes responsibility of the principal employer, but principal employer can recover that amount paid to the contract labor as a debt from contractor. So it can either be adjusted against future billing or it becomes a debt to be recovered by by the principal employer from the contractor. So that's third condition. Again, very very important condition. If in any organization contract labor are not paid by the contractor, it becomes responsibility of the principal employer, and therefore principal employers, whenever hiring contract labor through third parties, should check on monthly basis whether or not contractors have paid wages to the individuals. So that's condition number 3. Condition number 4 is to ensure full compliance under PF and ESI. So both PF, Employees Provident Fund and Miscellaneous Provisions Act, and Employees State Insurance Act puts ownership, obligation, responsibility on the principal employer to deposit PF and ESI for contract labor. And of course, if the contractor is already a registered establishment under PF and ESI, contractor will pay directly. But the ownership of ensuring compliance with PF and ESI specifically under these two specific laws, PF Act and ESI Act, is on the principal employer. So again, the market practice is that the principal employers will collect evidence of contractor having paid PF and ESI on monthly basis so that they comply with this condition or obligation on the principal employer. Then in the when we were discussing obligations of contractors, we discussed that the contractor is required to provide various benefits or facilities like canteen, restroom, first aid facilities, washing room facilities to contract labor. There is an equal obligation on the principal employer. So it says that in case the contractor is unable to provide or have defaulted in providing these facilities to contract labor, again the obligation shifts from the contractor to the principal employer. So again, principal employer should ensure that all of these facilities are provided to contract labor on regular basis. And the last is again what we discuss for contractor also, to ensure that the payment of wages is made in the presence of authorized representative of the principal employer. This is impractical in today's practical scenario, but generally principal employers will collect evidence from contractor on monthly basis, evidencing whether or not salary payouts have been done by the contractors. But these are six key obligations of principal employer. Any organization that has contract labor from multiple vendors or contractors need to ensure compliance with these conditions. And as chartered accountants, we can advise clients on this. We can also help them with vendor audits to ensure that clients, contractors are complying with these compliances under the CLRA Act. So these are obligations of the principal employer. Again, Supreme Court of India ruling. This is People's Union of for Democratic Rights and Others versus the Union of India, 1982 ruling by the Supreme Court of India. In this case, the contractor has defaulted to provide specific benefits or facilities required under these sections 16, 17, 18, and 19, and the the labor authorities raised an argument that if the contractor has defaulted, the principal employer should provide. Um, and the principal employer challenged that. When the matter went to Supreme Court, the Supreme Court, in very clear terms, if you read the last two lines, it says if the contractor do not carry out the obligations imposed upon them by any of these sections, which is the sections which require these facilities to be provided, then the principal employer would be liable and these obligations would be enforceable against them, which is the principal employer. So when you have employees through contractors, it's important that all of those obligations that we've seen on the earlier slide are 100% complied with on regular basis by the contractor. Otherwise, the principal employer can be made liable. So those are the obligations of the principal employer and contractors. Now, let's just take a few more judicial precedents on this topic. So this is a Kerala High Court ruling in the case of Cominco Binani Zinc Limited versus Papachan. This is a 1988 ruling where the court, so there's always this debate that wages contract labor for contract labor is principal employer's responsibility. But what is wages? Wages is a term defined under Payment of Wages Act. So CLRA Act does not have their own term definition of wages. They draw reference from the Payment of Wages Act. Uh, so therefore, what is wages is debatable. In this case, the Kerala High Court took a view that gratuity and bonus um, are not components that are covered in the definition of wages. So while principal employer is liable for paying wages under the act, they're not responsible for paying gratuity and bonus um, under the CLRA. So that continues to be contractor's responsibility, not the principal employer's responsibility. So another dimension that I'm giving you is the fact that when we talk about principal employer's responsibility for payment of wages in the event of default by contractor, what constitute wages becomes important. In this case, the Kerala High Court took a view that gratuity and bonus are not covered under wages, but there's a contradictory ruling uh, by Madras High Court. This is the latest 2012 recent, not recent, but like 2012 ruling, where the court held that gratuity, being a termination payment required to be paid under law, would constitute wages, and the principal employer would be responsible for payment of gratuity in accordance with the Salary Act. So you see the contradiction. And this is a later ruling by another high court. This matter has not been upheld by Supreme Court till date. But the latest ruling by Madras High Court is that gratuity also is covered in the definition of wages. So if you have contract labor working for 5 years or more and contractor has defaulted the payment of gratuity, then it also becomes responsibility of the principal employer. So therefore, principal employer should be responsible for payment of wages and also gratuity under the Payment of Gratuity Act. This is a 2012 ruling by Madras High Court. Yeah. Um, on bonus, I think the position is still settled. So this is a 2013 ruling by Karnataka High Court, which still holds the view that uh, uh, that the contractor is liable for payment of bonus. Requirement to pay bonus is not on the principal employer. So under current law, if the contractor has defaulted in payment of uh, statutory bonus, that responsibility does not lie on the principal employer. So while principal employer is liable for payment of wages and payment of gratuity as per the 2012 ruling, but as per the 2013 Karnataka High Court ruling, bonus is still responsibility of the contractor and not the principal employer. So therefore, some of these aspects will have to be seen when determining who's responsible for what. The next aspect in this whole piece is restrictions on engaging contract labor. So, there's a common myth in the industry that you cannot engage contract labor for specific activities or specific roles. That may not be true because under the current CLRA Act, there is no specific, Sneha, if you move the slide, there are no specific obligations or restrictions or prohibitions on engaging contract labor for core activities. So under the current law, there is only a authority given to appropriate government, which in most cases is the state government. There is only an authority given to state government to prohibit engagement of contract labor in specific activities or specific rules. But it's only the state of Andhra Pradesh among all the 36 states and union territories that we have in India. It's only the state of Andhra Pradesh that have restricted engagement of contract labor for core activities under the current law. Now, if you look at the labor codes, again, if you look at the Occupational Safety, Health, and Working Conditions Code, there is a specific prohibition on engaging contract labor for core activities, subject to three exceptions. But generally, under the new labor codes, an organization cannot engage contract labor for core activities of the organization, except three exceptions. Exceptions are where the normal functioning is ordinarily carried on through a contractor, or where the work is such that do not require a full-time worker, or there's a sudden increase in the volume of work. Then for temporary basis you can engage contract labor. If we are covered under three exceptions, then we can engage contract labor for core activities. But otherwise, organizations will have to look at alternate hiring models for core activities. And the alternate hiring models could be either we hire on roll permanent employees, or we do FTE, which is fixed term employment, or we hire consultants and retainers. But this is a very important development from a labor codes perspective, where now pan India engagement of contract labor for core activities will be prohibited, subject to the three exceptions that we've seen now. Again, the big question is, what is core activity? Um, so if you move the slides, Neha, if you look at the definition of core activity under the labor codes, core activity means any activity for which the establishment is set up and includes activity which is essential or necessary for such activity. So basically, core activity is the main activity for which the establishment is set up. Now, if you apply that again in a factory scenario, if a factory is set up for manufacturing, then manufacturing becomes the core activity, right? Which means that unless we covered under one of the exceptions, we cannot engage contract labor on shop floor or for manufacturing activities. And imagine the impact it would have, because currently, like I said, factories, most employees are engaged through contractors or third party. But engagement of contract labor for core activities is prohibited, and core activity means the main activity for which that establishment is set up. Now, there are specified activities which are exempted from core activities. So, work like sanitation work, security work, canteen, loading, unloading services, maintaining guest house, transport services, courier services, civil construction work, gardening, maintaining lawns, housekeeping. Some of these activities are not covered under core activities, so we can continue engaging contract labor for these non core activities. But once the labor codes are notified or implemented, identifying what is core versus non core becomes very, very important, because if an activity is core and we do not fall under one of those exceptions, it may become difficult for us to engage contract labor for those core activities. Now, I spoke about alternate hiring model, and I spoke about this new form of hiring called fixed term employees. If you understand the background or the nature of fixed term employment, I'm sorry, fixed term employees basically means engagement of employee on the basis of written contract of employment for a fixed period. So if you have an individual who's employed for a fixed duration, then that person qualifies as a fixed term employee. And if that person is asked to leave after the fixed term, then that does not constitute retrenchment under labor codes. Now, fixed term employees are permitted under the current law by way of Standing Orders Act. Um, but under the labor codes, there is a general permission. Any organization under labor codes can engage fixed term employees. The only two conditions applicable under labor codes for fixed term employees are: A, they have to be offered the same wages and benefits as permanent employees doing same or similar kind of work, and second, gratuity, which for permanent employees is applicable after 5 years of service. For fixed term employees, gratuity is applicable after 1 year of service. Those are two added conditions that are applicable for fixed term employees. But organizations that are not able to hire contract labor for core activities can look at an alternate way of hiring, which is fixed term employees under the new labor codes. Now, before I talk about additional obligations, I don't know, Manmichi, are there any questions or specific points that you would want me to cover, or are there any questions from the audience that we can cover now?
I request members, if there are any questions, they can post and we can take up the questions.
Sure. Till then, I'll continue.
Okay.
Okay. Now let's look at. So we spoke about obligations for contractors. We spoke about obligations for principal employer under the current law, and we spoke about restrictions on engaging contract labor for core activities under the current law and under the new labor codes. Now, under the new labor codes, there are some additional obligations for principal employer that principal employer needs to comply with. Let's look at those. The first is, and there are six new obligations on principal employer under the new labor codes. The first is prohibition on engaging contract labor in core activities, uh, which we've discussed. That principal employer cannot engage contract labor for core activities under the new labor codes. Second, this is a change. A principal employer is required to pay minimum bonus in case of failure by the contractor under the current law. And I also explained the 2013 Karnataka High Court ruling, which held that for statutory bonus purposes, the responsibility is on the contractor only. That would change under the new labor codes, because now under the new labor codes, if the contractor has defaulted payment of bonus, that responsibility to pay minimum statutory bonus, which is 8.33% of applicable minimum wages, that responsibility is on the principal employer. Third, the contractor is required to obtain license. It is the responsibility now of the principal employer to ensure that the contractor has obtained license. See, understand under the current law, the contractor is required to obtain license, the principal employer is required to obtain registration certificate, and both are responsible for their respective compliances. Under the labor codes, it becomes responsibility obligation of the principal employer to ensure that the contractor has obtained necessary license. Otherwise, the contract labor arrangement will be considered null and void. Then number four also is very important. For the first time, while it does not exist under the current law, for the first time now, the principal employer have to make payment to the contractor before the date of payment of wages to contract labor, which means that if the contractor, say for the month of July, is making salary payout to contract labor by 31st July, now it becomes responsibility of the principal employer to make payment of uh, wages to contractor before 31st July, which is a new obligation. So therefore, contractor principal employers have to ensure that they pay wages to contractor much in advance. Principal employer responsible for maintaining health, safety, working conditions. In the new labor codes, there is a chapter on various health, safety conditions, uh, and it becomes responsibility of the principal employer to maintain those safety conditions. And lastly, to provide various welfare facilities like canteen and others, including creche facility for contract labor. So these are some new obligations on principal employer under the labor codes which one need to comply with. Now, again, if I were to just give you a recap of multiple aspects that we've discussed up until now, we've looked at the definitions of contractor, contract labor, principal employer, when would it be applicable. We've looked at possible scenarios um, where CLRA Act will be applicable or not applicable. We've looked at obligations of contractor, obligations of principal employer. We've seen when is it not possible to engage contract labor for core activities, and we've also looked at additional obligations for principal employer under the new labor codes. Now, as towards the end of the my session or topic, I will cover some possible risk that I have seen in the industry when companies engage contract labor through third parties. And I'll present this through some case studies and judicial precedents. Now, they've been when a principal employer engages contract labor, one of the important risk that the principal employer takes is some of these allegations that contract labor makes sometimes, that they are not employees of contractor but direct employees of principal employer. Now, this is again a landmark ruling in the case of Steel Authority of India Limited versus National Union Waterfront Workers and others, where the Supreme Court of India in 2001, and I'm not going into get into all facts and all, but the Supreme Court of India in this case took a view that if the arrangement between contractor and contract labor is a sham contract, which means that while you have engaged employees through a contractor, but all hiring related decisions, all service conditions were decided by the principal employer, in that case, individuals will not be considered as employees of contractor, but can be considered as direct employees of, of the principal employer. So therefore, contract labor may be considered as direct employees of the principal employer if employer-employee relationship is established between them. So therefore, very, very important when companies engage contract labor, there should be level of difference. The hiring related decisions, the increments, a lot of these conditions should be decided by the contractor and not by the principal employer. Because if ultimately everything is decided by the principal employer, why should they be considered as employees of contractor? Is the question that Supreme Court of India raised in this case. So therefore, it should be ensured that the arrangement between contractor and contract labor should not be considered as a camouflage, should not be considered as a sham contract, and ultimate hiring related decisions, employer employee related decisions should lie between the contractor and contract labor. The principal employer should only be a user of the employees, should not be considered as employer of the individual employees. So that's one risk. Similar to this, this is another case by Bombay High Court. In fact, this is a recent ruling in the case of Chalet Hotels versus uh, Bhikan Lakshman Dwaikar and another. This is a January 2024 ruling. And in this case, actually, the Bombay High Court went into little bit more details. So the Bombay High Court, again, the question was whether the individual should be considered as direct employees of the principal employer. And the court looked at all of these factors. Who has the right to appoint the workers? Who is paying salary and remuneration? Who has the authority to dismiss the workers? Who can take disciplinary action? Whether there is continuity of service? To what extent control and supervision is exists between the contract labor and the principal employer, uh, and whether or not the principal employer has the required registration and whether or not the contractor has the required license. If all of these conditions are, or depending on all of these conditions, the contract labor may be considered as direct employees of the principal employer if employer-employee relationship is established between them. Now, one may ask, what if they are considered as direct employees of the principal employer? It can be a huge challenge, right? Because if the contract labor is considered as direct employees of the principal employer and the principal employer is letting go any contract labor, then they can demand retrenchment compensation under the Industrial Disputes Act, or they can demand wages or leave benefits directly from principal employer under the respective laws. So whether or not principal employer is responsible as employer is a critical factor from a contract labor perspective. Again, a very similar ruling by Madras High Court, uh, where, okay, in this ruling, actually, Madras High Court took another dimension. They said that if the a contractor has no license under the CLRA Act, then authorities have no way of regulating that contractor. And if that is the case, then they will not be considered as employees of the contractor, but as direct employees of the principal employer. Now, if you see, this issue has been addressed under the new labor codes by making principal employer responsible for ensuring that the contractor has the required license. That rule does not exist under the current law. But in 1984, Madras High Court have already taken this view that it ultimately is the principal employer's responsibility to ensure that the contractor has obtained license. If the contractor does not have the required license under the CLRA Act, the authorities will not be able to regulate the contractor, and the individuals will be considered as direct employees of the principal employer. So while technically there is no obligation under the current law for the principal employer to ensure that the contractor has required license, but if that contractor does not have the license, then like it was held in 1984, any labor authority or court can hold those individuals as direct employees of the principal employer. So that's again a very big risk uh, that sometimes principal employer would take. Then the second risk is these multiple allegations that sometimes contract labor claim that they need permanency in employment. If any one of you have dealt with a contract labor issues, this again a very common claim made by contract labor that they seek permanency in employment with the principal employer. The issue is the same, that if there is employer-employee relationship between principal employer and the individual, ultimately all hiring related decisions are made by the principal employer, then contract labor can be seen as permanent employees of the principal employer and not employees of the contract labor. Move on, Sneha. Um, Similar ruling by in 2024 by Supreme Court of India, where the court said that contract labor may be entitled to regularization or permanency in employment with the principal employer if they're performing regular or perennial nature of work. So if they're really working like regular employees, they're working on a long-term basis, they're subject to all rights, control and supervision by the principal employer, then they can be considered as permanent employees of the principal employer, and the arrangement between contractor and the individual can be disregarded by the court. This is a recent March 2024 ruling by Supreme Court. Yeah, this concept you've discussed earlier also. So this is where the contract labor claims that they should get the same wages and the same benefits as that of permanent employees of the principal employer. On this, courts generally have taken a view that this obligation is on the contractor and not the principal employer. So unless contractor arrangement is seen as a sham contract, this responsibility of paying same wages and same benefits is on the contractor and not the principal employer. So this case also, Calcutta High Court ruling in December 2023, the ruling is that the contractor is liable to ensure same wages, same rate, same holidays, same hours of work, same conditions of a service to contract labor as compared to regular employees doing the same and similar kind of work for principal employer. This is a liability of contractor and not the principal employer. So I thought I'll just cover some of the recent court cases and risks that we've seen in this space. Now to conclude, this is the probably the last slide that I have on the deck, and then I'm happy to take up few questions if there are any. Now, what I would recommend that organization should do, I would recommend that these are 8 steps that an organization should follow when engaging contractor labor. First, look at or explore alternate engagement models and set up very robust process to identify contract labor relationship. I discussed the various definitions of contractor, principal employer, contract labor. I discussed the various scenarios on when contract labor relationship has to be established or can be established. So a company should look at different hiring models and see when contract labor relationship is established. Second, put in adequate guardrails for the rules and the period for engagement of contract labor. Because, like we discussed in one of the rulings towards the end, if they are working on core activities, they're working on regular basis, they're working on long-term basis, they're carrying on major activities in that organization, then there are multiple cases where courts will disregard the contract labor relationship and hold them as permanent employees of the principal employer. Third, where we not able to engage contract labor for core activities, etc., do explore. There are multiple hiring models that exist in the industry. So explore fixed term employment, consultant relationship, retainer relationship. Then two contracts are very important, point 4 and 5. One is the contract between the contractor and the principal employer, and second is the contract between the contractor and the individual employee. What are the risks, reward, relationship, obligation in these contracts will define obligations for contractor and principal employer. So these two contracts definitely should be seen. Point number six, and this can also be an opportunity for us as chartered accountants to ensure that the contractor has the valid license and the principal employer has the required CLRA registration certificate, and we can help our clients obtain these licenses and registrations. Point number seven, to minimize or mitigate risk for the principal employer, that general industry norm is that the principal employer would conduct vendor audits on regular basis to ensure that the contractors are compliant. Those vendor audits, again, something that us as chartered accountants can do for the organizations, and ensure that all the benefits and service conditions are provided to contract labor as required under the various regulations. So, as long as we follow these 8 steps, the risk can be mitigated. But a lot of these cases happen, and a lot of this litigation happen because somewhere some of these 8 steps are not followed. So, if we follow the 8-step approach, then a lot of these risks that we've spoken about, a lot of these obligations um, that we've spoken about, do get addressed on a regular basis. So this is my recommendation that organizations should follow. So that's it from my side. I've spent good 1.5 hours taking you through all the multiple aspects of contract labor relationship. This is a technical topic, so I'm sorry if this was um, too detail oriented, but I just thought that I'll cover this for our fellow chartered accountants. Happy to take on any questions or answer any other scenario that you've seen or would want to discuss.
We have this first question from Gaurav Sharma, sir. Whether a person whose 90% work is to operate a machine and 10% supervisory role, as well to look after work of two subordinates, whether such a person would be excluded from workman definition. Sir, you are mute.
Manmeet, I was asking who's asked this question. This is a very interesting question.
This question is from Gaurav Sharma.
Okay, Gaurav, a very, very important question that you've asked. In fact, I would congratulate you for asking this question. There are multiple court cases in India where courts have held that supervisory role is different from a coordination role. The courts have held that where, say, you have individuals reporting into a person, where the person is giving them day-to-day instructions, etc., but not really does not have control, supervision over those individuals. You're not able to do performance evaluation, you're not able to grant leave. That is not supervisory role. Supervisory role means that you are responsible for your team and for your juniors. If that is the case, whether that is 10% or 50%, you will be seen as supervisory role. But if you only are in a coordination role, give them general instructions, but not really responsible for them on a day-to-day basis, then that will not be supervisory role, and that person will not be excluded from the workman definition. So person has to be a supervisor, someone who's a manager responsible for that person on a day-to-day basis.
So the next question is from Mr. Alok Kumar Gupta. The question is, we are not entering into contract for supply of service, but for contract for service. However, the client has declared our details in his RCS contractor. How to deal with the compliance obligations in such scenario?
Yeah, so it's a very, very common issue in the industry because, like I said, who is a contractor, who's a contract labor, what is a contract for services, what is contract for manpower supply are very complicated aspects in India. The general industry norm is mostly clients or organizations uh, are conservative in this approach, and like especially if you're taking on blue collar jobs or low wage earners, companies generally cover them under the CLRA-RC. But if it is a pure contract for services where there is no direct manpower supply, then you can actually work back with your client um, and ensure that CLRA RC is amended and that name is removed. It can be a simple amendment and that name can be removed, because when you take a CLRA principal employer registration certificate, the principal employer then each contractor is mentioned and each contract labor details are given. So if we agree that the contract labor relationship does not arise, then the principal employer can be asked to get an amendment of the RC and remove that name of the agency from the list of contractors. But for that, a fact specific evaluation has to be done, because what I discussed in the call or the webinar today are broad principles, but these principles will have to be applied in each specific case.
So the next question is from Mr. Avinash Gurumurthy. What is the benefit of hiring contract employees for an organization if there are so many restrictions and obligations attached to hiring of contract labor? Who is
I
responsible?
asked, sorry,
Who is responsible for the statutory dues like LWF, professional tax, etc. of contract employees? The principal employer or the contractor? Can the statutory auditor of principal employer obtain certificate from contractor that all statutes laws have been complied with?
okay. So three questions have been asked, three independent questions have been asked. I'll try and answer all three of them. First, what is the use of engaging contract labor? See, the general industry norm is that organizations believe that hiring and firing is easy when you engage employees through a contractor, because if you have employees on rolls and those are asked to leave, that could be seen as retrenchment under Industrial Disputes Act, where companies have to pay retrenchment compensation and take approvals from the labor authorities. So to bring in flexibility in hiring and firing, companies generally engage individuals through contract labor. So that's why normally you see organizations hiring contract labor. On your second question around LWF and PT, Labor Welfare Fund and Professional Tax, generally it is the contractor who's responsible for LWF and PT compliance, not the principal employer, because the contractor is the legal employer for these individuals. And these payroll compliances like labor welfare fund and professional tax should be complied with by the contractor, not by the principal employer. Third question you asked is again a very important, relevant question. Can the principal employer just take a certificate from the contractor that the contractor is compliant? While again, that is the norm in the industry, sometimes, especially large contractors would do that. But please understand, from a law perspective, from whatever we've discussed under these CLRA perspective, some of these obligations do fall back on the principal employer. So, for example, you've taken a certificate, but the contractor has still defaulted on the PF compliance. That obligation can still be passed on to the principal employer. Or you've taken a certificate but the contractor has underpaid ESI contributions, that risk is still on the principal employer. So taking a certificate may not be 100% ideal, because that will not absolve us from our responsibility as the principal employer. That may only be done in case you have that comfort with the contractor that the contractor is compliant. But normally speaking, a vendor audit is done in these situations so that contract the principal employer has proof that the contractor has done those compliances on regular basis. So that's generally the norm in the industry, to get vendor audits done on regular basis. I hope I've answered all the three questions.
So the next question is from Mr. Gaurav Sharma. What is the difference between temporary workers, casual workers, and contract workers as mentioned under standing orders rule?
Yeah. So simple. Um, Contract labor is what is covered in the CLRA Act, right? So when you hire through a third party, those are contract labor. Casual labor or temporary workers are more generic terms. So like you, especially like in some industries where you do daily wage hiring, or you do short term hiring, those are considered as temporary hires or casual labor. Um, but these are terms which are interchangeably used. So contract labor means hiring through a third party where the arrangement is covered under CLRA Act. Casual or temporary workers are generally employees that are engaged by the company for a short period or for daily wage basis.
So the next question is, how can contractor ensure that payment of contractor workers is at par with the regular employees of the principal employer?
That should be ensured when you make the arrangement between contractor and the principal employer. So when the contractor is signing the contract with principal employer, contractor and principal employer should clearly agree two things. Number one, whether principal employer have on-roll employees doing the same work which the contractor is going to do, and second, if yes, what will be the salary breakup, compensation breakup for the contract labor? That should be a while the law puts that onus on the contractor, but contractor cannot on its own know what is the principal employer giving, right? That has to come from the principal employer. So the contract between the contractor and the principal employer have to ensure that it clarifies that together both the principal employer and contractor have undertaken that responsibility of providing the required benefits and service conditions to contract labor, which have to be at par with those provided by principal employer if they have on-roll employees doing the same or similar kind of work.
So the next question is, if the contract worker headcount is below the threshold, does the contractor still have to adhere with the CLRA rules? Also, is
No.
the contractor responsible to share monthly declarations with the principal employer?
Okay. Again, good point. So number one, from a CLRA license perspective, if the contractor has less than the threshold limit, then the contractor is not required to obtain a license, and the principal employer is not required to obtain a registration certificate. So those are not required if the employee count is below the threshold. But the contractor may still be liable or responsible to provide especially PF and ESI related documentation to the principal employer, even where the threshold is not met, because under PF Act and ESI Act, the contractor relationship is not dependent on employee threshold. So even if you have one individual who is taken as contract labor, from a PF standpoint, that is still an obligation of the principal employer, and therefore principal employer can ask contractor to furnish PF and ESI records. So that may still be required, but license or registration certificate under CLRA will not be required if the threshold is not met.
So the next question is, 1 second. If a principal employer has obtained registration under CLRA Act because contractor A has supplied 20 workers, but there is contractor B who has supplied only 10 workers, does the principal employer needs to endorse name of contractor B on its registration certificate?
Yes. Very, very important, relevant question. Uh, when you see for principal employer registration certificate, you see overall count. If from all contractors you have total contract labor above the threshold, then all contract labor and all contractors should be disclosed in the RC, in the principal employer RC. Whether from one contractor you have one employee or 20 employees, all the contractors should be reported in the principal employer RC. From a contractor license perspective, understand practically, contractor license is availed for each principal employer. So if a contractor is providing uh, contract labor to 100 clients, the contractor has to obtain 100 licenses only where the individual supplied to a particular principal employer is exceeding the threshold. So let's take principal employer entity has 50 contractors providing say two people each. You above the total threshold, the principal employer will have to take up principal employer registration certificate for all the 50 contractors, but the contractors don't need a license because for each client they are providing less than the required threshold. So you have to see the threshold differently for principal employer. For principal employer it's consolidated. For contractor license it is for each individual client, each individual principal employer entity.
So this is in continuation of the question. Uh, that's it. Whether a person whose 90% work is to operate a machine in factory and rest 105 work involves to supervise activities of two subordinates working with him. Thus, this person falls under supervisory capacity and will be excluded from workman definition under CLRA Act.
Manmiji, we've discussed this when we discussed the first question. So percentage does not matter. What matters is whether or not you have ultimate control and supervision of the individual. If you're more in a coordination role, then you're not a supervisor and still a workman. But if you really have control supervision, whether it's one individual or 10 individuals, if you have control supervision of an individual, then you are in a supervisory role and excluded from the definition of workman.
So the next question is, what are your views on obligation of bonus on contractors towards contractual employees, although for many years they are being deployed at a particular establishments?
No, so you've raised two questions. Generally, technically speaking, for statutory bonus, it is the responsibility of the contractor and not the principal employer, technically as per law. But if you're saying that a company has engaged contract labor for, say, same person for 10 years as contract labor, then the risk of permanency in employment that I spoke about towards the end of my presentation, those would apply. Then the contract labor can argue that the contract labor arrangement is all camouflage and sham, and I should be considered as direct employee of the principal employer. If someone is working for 10 years in an organization, it's like a regular employee. In that case, principal employer may be liable. But if you have a pure contract labor relationship, then generally, as per law and as per judicial cases, it is statutory bonus is a responsibility of the contractor and not the principal employer.
Okay, so in the last question, they have a continuing question that does that mean contractor B needs to obtain license also in the previous question?
No, so contractor needs to obtain license if contractor is providing contract labor to a particular principal employer exceeding the threshold. I'll repeat. A contractor is required to obtain CLRA license if a particular contractor is providing contract labor to a particular principal employer exceeding the threshold. Only in that situation, the contractor is required to obtain CLRA license.
So, sir, there is a question that I want to know why the act is named that Contract Labor Abolition Act if the aim is to facilitate the welfare of contract employees.
Excellent question, because the when they started with the law, they wanted to abolish contract labor, because if you remember, this was, I think, 1970, right? So when they started the law, 1970, when they started the law, um, uh, the whole intention of the law was to abolish contract labor and provide more benefits to contract labor. Now, over the years, a lot of guardrails have been put in the law, and a lot of amendments have been done, where it is not just about abolition, or it's not about abolition, but it's also about providing welfare benefits and safeguarding the interest of contract labor. So yeah, that's a very good observation that you have.
So, we have another question. What are the roles of SA in respect of contractual arrangements?
Can clarify what do you mean by essay?
Mr. K. Swaminathan, can you please explain? Sir, can you please pose the question in detail? I request members to post their question if there are questions. Statutory auditor, sir, he has posted, what are the roles of statutory auditor in respect of contractual arrangements?
Again, good question. Basically, to ensure that if the statutory auditor is auditor for the principal employer, ultimately statutory auditor has to ensure that the principal employer is compliant with all of these conditions, because if they're not compliant, then the authorities or the individuals can demand these benefits from the principal employer, which becomes a financial liability which the statutory auditor should account for. If you are statutory auditor for the contractor, you need to ensure that as contractor you are compliant, because again the obligations can be passed on to the can come to the contractor. So statutory auditors, in the right sense, should look at these aspects, especially in organizations where you have large scale contract labor hiring, whether as principal employer or as contractors. Because understand this also, that under CLRA Act, there are some very severe consequences of non-compliance. That this is one law where there still can be imprisonment for non-compliance with required obligations under the CLRA Act. So therefore, as statutory auditors, both for contractors and principal employers, one need to ensure that the conditions are complied with.
So that was all the questions. I request the audience to post any questions if they need any clarification. So there is a question. The principal employer has undertaken a contract for supply and installation. He appoints contractor for installation work at site. This contractor does not make PF payment for his labor as he does not have minimum labor employed by him. Now the principal employer needs to pay PF for contractual labor of contractor. Who should take PF registration? Contractor is not ready to take PF registration.
The principal employer should pay. If the contractor has less than 20 employees, contractor is not liable to take PF establishment registration. In that case, there are enough rulings and also coming from the law, the principal employer will have to do PF compliance for those contract labor.
Any other member has any query? Sir, it is a continuing question. How will the contract labor claim this PF paid by principal employer?
Doesn't need to be claimed. So when the principal employer will deposit PF contribution, the principal employer will create a universal account number for the contract labor on its code and deposit PF against that universal account number that belongs to the contract labor. So contract labor will have a member ID, a universal account number on the EPFO portal, and can claim benefit directly from the EPFO. So like principal employer will make PF deposit for their regular employees in exactly same form and manner. In this case, where the contractor is not registered, the principal employer will create a universal account number for the contract labor, or if the contract labor already has a universal account number, will link that universal account number to its PF establishment code and deposit monthly PF through the electronic challan cum return ECR every month, and the PF gets credited directly. PF contributions gets credited directly on the member's passbook on the EPFO portal, and the member can claim all the benefits directly from the EPFO, which is the Employees Provident Fund organization.
So the next question is, does the number of workers be location wise or contractor wise, supplying persons for same company but different location?
Again, if the appropriate government is the state government, so if it's a service company, manufacturing company, then have to look at employees in each state because the jurisdiction will be different for each state. But it's a little fact specific. We'll have to look at it because sometimes what is state versus what is central can be debatable. But generally speaking, it has to be different each employees in each state.
So the next is, clarify on number of contract employees location wise for same company.
I didn't understand. Clarify.
Clar- on number of contract employees location wise for same company.
Like I said, we'll have to look at specific facts because if it's covered under a common contract, then we may need to see total contract labor population. But if the contract very clearly states that different employees will be posted in different states working for different branches, um, for different offices, then we can look at state-wise also. So it depends on really how it's the arrangement between contractor and principal employer structured, uh, to what extent they have various registrations under SNE Act, how are the employees working, are they working from specific offices, are they tagged to specific offices. So it's a fact-based exercise. It cannot be a standard yes or no answer.
Contract labor entitled to trainings.
Not as per law. If they claim permanency in employment and that is upheld, then yes. But like there is no statutory requirement in India anyways for employees to be provided training.
If multiple contractors who are below threshold limit, employing below 50 workers, supply workers amounting to more than 50 to the principal employer, then whether principal employer needs to correct RC from all the contractors.
So RC is not taken by contractors, RC is to be taken by principal employer. I'll re-clarify my statement. If a principal employer is required to obtain CLRA RC, I'll repeat, a principal employer is required to obtain a CLRA registration certificate if that principal employer has engaged contract labor exceeding the threshold from one or more contractors in aggregate. Right? So if a principal employer has taken contract labor from multiple contractors, each individual contractor is below the threshold, but in aggregate it exceeds the threshold. The principal employer is required to obtain principal employer registration certificate under CLRA. For contractor, you have to look at contract labor to each individual principal employer. So in this scenario, where for each contractor, the number of employees are below the threshold, while the principal employer will need a principal employer registration certificate, contractors do not need contractor license because contractor license is required if number of contract labor provided to each individual principal employer is exceeding the threshold. Then you take license for that particular principal employer. So for contractor license, it's per principal employer. For principal employer, it is aggregate from all contractors.
Can deposit of PF by principal employer be reason creating direct relationship with contractor?
Yes, of course, it can be because then you're admitting that the contractor was non-compliant. If they were non-compliant on PF, they can be non-compliant on many other things.
Any other questions from members? So there's a question. Principal employer is responsible only for minimum wages as per the state's PF and ESI. They are not responsible for PT, LWF, and bonus.
Yeah. So they're not responsible for PT, LWF, and bonus. I agree. Again, subject to specific facts and fact that there is no permanency in employment, etc. They're not eligible for PT, LWF, and bonus. Um, while it can be litigated sometimes, so therefore companies always err at the side of caution. Uh, but from a wages perspective, they're not just responsible for minimum wages, but actual wages of the contract labor. So if the contractor has agreed to, say, pay 20,000 wages to contract labor, while the minimum wages is only 15,000, and the contractor has defaulted, the principal employer will be liable to pay the entire 20,000 rupees, not just minimum wages to the contract labor. Of course, if the contractor has agreed to only sign up contract labor or engage a contract labor only at minimum wages, then principal employer is also liable only to pay minimum wages.
Any other questions from members? An injury to contract labor and work responsibility.
Again, highly debatable because sometimes injuries and death at workplace are seen very differently. You'll have to look at Employees Compensation Act and liability under Employee Compensation Act, and some of these aspects will always be cautious because the law is not clear and there are contradictory rulings sometimes. So in matters like that, you like be extra careful. I would want to look at specific facts before I opine.
Any other questions, members? There are no more questions, sir. Before winding up the session, on the behalf of committee and all the audience, I would like to extend my sincere thanks to Dr. Puneet for sharing his expertise with us. It was quite an
CA
engaging
Puneet, I'm
session.
sorry, I'm not a doctor yet. I'm CA Puneet.
Okay, okay, okay. So, sir, that was quite an engaging session, and the inputs were really valuable. I think all members will agree with us. And thank you to the audience for connecting us. I thank the committee for providing me this opportunity to be a moderator. A very good evening to all of you.
Sure. Thank you. Thank you so much, CM and Meet. I think you've done a fantastic job in keeping us together. So thank you so much for that. Thank you, of course, to the committee for giving us all this opportunity. And thank you, dear members, for raising such practical insights on a topic as technical as this. So real pleasure to be here. Thank you so much and have a good evening. Bye bye.
My pleasure. Hello. Yeah.